Well, I think we're all just about settled, and so I'd like to commence by welcoming you all here to another in our Greenway series of continuing professional legal education. I'd also like to extend a welcome to those that are joining us over the interweb in whatever streams or ponds that you are in. Thank you for joining us, and we are sure that this evening's presentation will be both topical and informative. Since 1987 and the seminal decision of Pavian, Matthews and Paul, a restitutionary quantum meruit has featured large in many building and other cases associated with contracts, and in particular the termination of contracts. There has long been identified a tension in the law as it stands between the rights and entitlements of parties following the termination of contract and the ancient common law money count of indebitatus assumpsit, which allowed one to sue for a restitutionary quantum meruit on the fiction of a quasi-contract or entitlement to receive a reasonable sum for work performed to date. Before the High Court presently is a decision from the Victorian Court of Appeal called Mann and Paterson, which is examining, amongst other things, principally the situation of the contract and the entitlement to a restitutionary quantum meruit, given the tensions and apparent inconsistencies between the rights and entitlements of the parties that arise therein. Our first speaker tonight, Derek Hand, specialises in construction law in particular, but as well as other areas, and has encountered this issue and these issues many, many times, whether in the context of structural projects, infrastructure projects, large-scale residential, or indeed small-scale residential. I'm sure you can all read his biography on our website. It's very impressive, I'm sure you'll agree. I won't read it now for you, but simply ask Derek to join us and to make his presentation.
Thanks, Frank. Thank you. Lucas and I have divided the workload, as it were, between us in this way. I'm going to make some introductory comments about quantum meruit, and then consider three or four cases in which this question of restitution has arisen, and these cases form part of the discussion that was before the High Court most recently in this matter. Lucas will pick up the story then at the High Court and address you on the submissions that were made before the court, both written submissions and oral submissions. Now, an admission that we must make is that we had hoped that there might be a decision from the High Court prior to tonight, and that we would have the opportunity to discuss the decision with you. That was misplaced optimism on our part, and that's just the way it is. But when the decision is handed down, we will resume and invite you back to chambers then to discuss the decision. So if we start in setting the scene to look at what is a quantum meruit, and of course a quantum meruit is a claim for the value of work done and services provided. As Frank mentioned, the current state of the law here in New South Wales is that where a contractor under a construction contract accepts a repudiation of that contract by the principal and terminates, it's entitled to recover on a quantum meruit basis up to the date of termination instead of claiming damages in contract. Both remedies are available, and a contractor may elect between the two. That is, a claim in restitution on quantum meruit or a claim for damages in the breach of contract. When one looks at this area, a question that immediately comes to mind is, well, what's the doctrinal basis for that availability of a quantum meruit in the context of a construction contract? And one idea that's put forward is that the notion depends upon the idea that upon the acceptance of the repudiation, the contract is avoided ab initio. And Lucas will return to this in his submissions, but it's the so-called rescission fallacy. That is the fiction, if you like, of the rescission of the contract upon the acceptance of the repudiation. The availability of the remedy in restitution has been much criticised, both in academic literature and indeed in the decisions. And in the latest edition of Keating on Construction Contracts, the authors argue that the availability of the remedy in restitution cannot stand, they say, in the face of the logic of the modern law of contract. And I've put there a quote from the textbook, the risk that of a substantial injustice if a contractor who's in a contract with a bad bargain may accept a repudiation, terminate the contract, and then in effect go back and rewrite the contract on the basis of very different rates than those that were the subject of the contract. That's the sort of the risk of a substantial injustice to which the authors refer. Let's turn now, if we may, to the case law. And the first case I want to discuss with you is the decision of the Privy Council in the case of Lodder and Slowey. Now, this was an appeal from the New Zealand Court of Appeal. And the facts are these. There was a builder who had contracted to construct a tunnel and to carry out some other works. In the course of the works, the principal excluded the contractor from the land and prevented him from completing his contract, in circumstances where that contractor was not in breach. The contractor accepted that repudiation and terminated for the principal's repudiation and brought an action in quantum meruit, or in the alternative, an action for damages in contract. At first instance, in fact, this matter was heard before a jury and ended up on appeal to the Court of Appeal. And the Court of Appeal held that in the circumstances of the case, the contractor was entitled to treat the contract as rescinded and to sue on a quantum meruit for the work and the labour provided and materials supplied prior to the rescission. That was the finding of the Court of Appeal. The Privy Council agreed with the Court of Appeal's position that the respondent, that is the contractor, had the right to treat the contract as having been rescinded. Now, this was 1904. If you've visited the reports from the turn of the century, they were far more brief rather in terms of the size of these decisions. This was a 7.5-page decision in the reports. And this question of the availability of a claim in quantum meruit occupies fully one paragraph of the decision. Now, I introduce you to this decision in laying the framework for what is to come, because there were a lot of references back to this decision in the course of this matter before both before the tribunal and towards the High Court. That was 1904. Let's jump forward by 30 years to 1933, about 30 years, and Justice Dixon in the High Court in the decision of MacDonald and Danny Lascelles, where His Honour considered the common law position in Australia. Now, this case arose from circumstances of the repudiation of a contract for the sale of land. And what Dixon J. held was that where a contract is terminated at common law by the acceptance of a repudiation, then the contract is not rescinded as from the beginning. Rather, the circumstance is that both parties are discharged from further performance, although rights that have already been unconditionally acquired are not discharged unless the contract provides to the contrary. That expression of principle is probably more consistent with our understanding in the modern law of contract, and certainly a rather different approach to what was adopted by the Privy Council 30 years previously in 1904. Let's now jump ahead by another 60 years or thereabouts to the New South Wales Court of Appeal in Renard Constructions and Minister for Public Works. Now, this was a contract, again a construction contract, for the construction of some pumping stations as part of a sewage project in Gosford. And there was a contract that an old scheduled rates contract with an estimated final value of close on $209,000. A dispute arose, and the principal took over the whole of the remaining work and excluded the contractor from the site. The contractor, we've all encountered these circumstances. The contractor in turn treated the principal's action as a wrongful repudiation, accepted that repudiation, and asserted that it had rescinded the contract, that is, that the principal had rescinded, and brought arbitration proceedings. Now, the arbitrator made an award in the contractor's favour of about $285,000. The principal appealed to the Supreme Court, where the court decided that the arbitrator's award should be set aside. The contractor then appealed to the Court of Appeal, and that's the decision we look at now. And one of the issues before the Court of Appeal was whether or not the amount of the quantum meruit, as claimed by the contractor, should be capped by the terms of the contract, keeping in mind that the contract price was about $209,000 and the award was much higher than that, about $285,000. The Court of Appeal held that there was no such cap or ceiling, that the contract did not operate, or the contract price did not operate to impose a ceiling. Now, this is pausing there. This is a matter that forms part of the consideration of the matters that Lucas will discuss later. Justice Marr, in his decision in Renard, stated the principle that where an innocent party accepts a repudiation, it has the option of suing for damages in contract or on a quantum meruit for work done. The law is clear enough, he said, and there set out the principle. On the question of the contract price as a cap on the amount that may be awarded on a quantum meruit claim, Justice Marr said that the contract amount may be evidence of the reasonableness of the remuneration, strong evidence perhaps, but it was certainly not conclusive evidence of the question. That's an important point that we'll come back to. On the question of whether a defaulting party, that is the party had repudiated, whether or not that party could be permitted to rely on the prices in the contract, remember it's a scheduled rates contract, that is, could it rely on the rates in the very contract it had repudiated? Justice Marr's response was very unambiguous. It would be extremely anomalous, His Honour said, if the defaulting party, when sued on a quantum meruit, could invoke the contract which he has repudiated in order to impose a ceiling. There was an application for special leave. It was refused. Let's go forward now to 2009 and a Victorian decision of Sopov and Kane Constructions. Again, there was a dispute between a construction contractor and its principals, this time over a progress claim and the principal's deduction of liquidated damages under the contract. It was a contract for the renovation of property in Collingwood. The builder again treated the principal's conduct as a repudiation and sued, terminated for the repudiation and sued in quantum meruit. Now, an interesting fact that jumped out at me was that the hearing before the trial judge in this matter took 37 sitting days, after which a quantum meruit was awarded. The principal appealed and the contractor cross-appealed against the assessment. Now, on appeal, the Court of Appeal in fact delivered two decisions. In the first decision, it found that the trial judge was correct in concluding that the contract had been terminated as a result of the acceptance by the contractor of the principal's repudiation. So the question of repudiation was determined on the first appeal. The court then sent the parties away to mediate and see if they could reach agreement on the balance of the issues in dispute. The mediation failed, and in its second decision, the Court of Appeal dealt with the question of the availability of a quantum meruit in the circumstances of that case, i.e. in the circumstances where a contractor accepts a repudiation, terminates, and sues for quantum meruit. And in that decision, the court noted that there was, quote, a growing chorus of criticism, judicial as well as academic, of the availability of quantum meruit in circumstances of repudiation. I'll just draw your attention to some extracts from the decision. Their Honours noted that the decisions in Lodder and Slowey, oft cited in support of the notion of the availability of the remedy, could be seen to have been premised on the rescission fallacy. Again, that's the notion that the acceptance of repudiation has the effect of rescinding ab initio. According to the critics, said their Honours in their decision, it's an error of principle to permit recovery on a quantum meruit in these circumstances. And the court says these criticisms are in fact very powerful. And unconstrained by authority, the court may well have come to a different finding, to its ultimate finding. But the court noted that in fact they were heavily constrained by authority, and in that regard, the refusal of special leave from the decision of the New South Wales Court of Appeal in Renard was of particular significance to the Victorian Court of Appeal in determining this matter. Ultimately, the Court of Appeal held that the builder was entitled to sue on a quantum meruit rather than for contractual damages following repudiation. It also held that the contract price was relevant, but merely as evidence to show the value that the parties had attributed to the work at a particular time. Consistent with what had been said in Renard, the contract price did not impose a ceiling on the amount that could be recovered on the quantum meruit. So that's the background. They're the cases I wanted to introduce you to before we come to the decision of Mann and Paterson, which was first heard at first instance before the Victorian Civil and Administrative Tribunal. So the facts are these. It's a residential building contract for the construction of 2 semi-detached units. There was a contract price of $971,000. Work commenced in March 2014, and about a year later, the principals purported to terminate the contract by correspondence from their solicitors, and they did 2 things that we all as practitioners see from time to time. They changed the locks and they denied the builder access to the site. Now this gets into that dangerous territory. This is the stuff that I think keeps construction lawyers awake at night, that question of is there a wrongful termination, a wrongful purported termination amounting to a repudiation which is accepted. Dangerous territory to be in, but this is where the parties found themselves. The contractor brought a claim before the tribunal for the value of the work and the materials on the traditional quantum meruit basis or on the alternative damages. And it asserted that by taking possession of the site and excluding it, the principals had repudiated. Fair enough. Again, as so often happens in these cases, the first question was, well, who had in fact terminated? Now, some 20 days were allocated to this hearing before the tribunal. 20 days of hearing. And the tribunal found that the principals had repudiated and, on the question of quantum meruit, applied the principles in Sopov. Now, if one comes to read the decision in the tribunal was quite robust in its findings on questions of credibility and really had grave concerns about the credibility of the principals, and by far preferred the evidence of the builder, the contractor, on important matters. Importantly too, the contractor had adduced evidence from a quantity surveyor as to the value of the work. The principals, the homeowners, they did not adduce quantum evidence from a quantity surveyor. What they had was some evidence from a building expert on questions of quantum, but that expert didn't cover every item of expense or of work that had been carried out. And in addition, one of the owners put on evidence as to the costs actually incurred, i.e. the invoices that I think had been discovered by the builder in the course of the proceedings. That's the invoices from the builders, or the contractors, suppliers and subbies, and had assembled those into a schedule and put them before the court as evidence. In assessing the amount of the claim, the tribunal observed that it was not in a position, it couldn't just cherry pick items. It couldn't just take items from one expert in one category and then items from another expert in another category, and rather felt that it was in a position where it must choose between the different expert opinions that had been adduced before the tribunal. The spreadsheet wasn't a valuation of the whole job, but rather had some gaps in it. Now, it's also important to note here that there was very little cross-examination of the quantity surveyor. Now, that may or may not have a bearing on on how the matter is treated before the High Court, but certainly throughout you will see commentary in the decisions and in the submissions that there in fact had been very little cross-examination of the quantity surveyor, and there was then the question of the reliability of the principles, or the credibility as before the tribunal. So the tribunal was satisfied on the basis of the evidence before it that the value of the work assessed without defects was 1.722 million, and then deducted from that the rectification costs of about $116,000, giving the value of the benefit conferred upon the owners, the benefit conferred of $1.6 million. Now, 1.606, keeping in mind that the contract price had been $971,000. So the owners were dissatisfied with this finding, and they appealed to the Supreme Court on questions of law. And there were said to be two underlying issues. The first issue was that the owners said the tribunal had misunderstood or misapplied the test or the principles that should be applied to work out the value of the quantum meruit. And what they said was that the proper test was to assess a value that was fair and reasonable. That required the assessor to take into account a range of matters which it had not taken into account. And instead, the tribunal had simply accepted the evidence of the quantity surveyor and that this was impermissible. Not so, said the Supreme Court. The Supreme Court on appeal said the senior member did not misunderstand or misapply the principles. So, fair enough. The second underlying issue concerns the proper interpretation of the Victorian, a provision of the Victorian Domestic Building Contract Act. Now, we're not going to dwell upon that tonight. If, when ultimately there is a decision from the court, we will return to that at that stage. The owners had also submitted to the Supreme Court, a single judge, that Sopov was wrongly decided, and the judge described that as a formal submission, given that it was common ground between the parties that in fact the court was bound by the Court of Appeal's decision in Sopov. We go then to the Court of Appeal, where the owners appealed, but without success. And the Court of Appeal held that, yes, a contractor was entitled to recover the fair and reasonable value of the benefit conferred in the circumstances of this case. Now, the Court of Appeal also observed that where the builder had relied on the evidence of a quantity surveyor, and the owners had elected to rely on evidence of the contract price and the actual costs incurred by the builder, then yes, the tribunal was required to have regard to all of that evidence in reaching its determination on the value of the quantum meruit. However, the weight to be given to any particular item of evidence depended on the circumstances of the case, including the tribunal's assessment of the reliability of that evidence. And I've there given you an extract where the court said the actual costs did not impose a ceiling on the amount that could be recovered. Before the Court of Appeal, the owners referred to the criticism of the status quo to which I referred earlier, that is the criticism in the academic literature and in the cases, and they invited the Court of Appeal to revisit the issue. They submitted to the Court of Appeal that this appeal presented a particularly good opportunity for the controversy to be further considered judicially. The contractor, would not surprise you, took a rather different view. It said that quantum Meruit had been available to a builder in these circumstances for more than a century, and that any change to that position would be a matter for the High Court. Indeed, in dismissing the appeal, the court echoed the criticisms that had earlier been made in Sopov and said that no occasion arose in circumstances where there was no submission that the earlier decisions were plainly wrong. No occasion arose for this court to consider the correctness of those decisions. However, the court echoed what had been said in Sopov and endorsed the observations that had been made in respect of the criticisms of the availability of this remedy in these circumstances. And with that, from the Court of Appeal, the matter went to the High Court, and I'll hand over to Lucas.
Thank you very much, Derek. And as Derek said, I'll pick up the story in Canberra, as it were. I expect that the builder in the Court of Appeal, when it made the submission that the High Court was the only place where this could be resolved, perhaps didn't expect that that would be the next step. But in any event, that's how it played out. You will have already picked up that the facts of this case are perhaps surprising in the sense that this is a matter that went all the way to Canberra. We haven't yet had the decision from the High Court, but I'll attempt in the next little while to run you through the arguments that were made in the court and also then the exchanges between the bench and counsel with a view to, I hope, indicating that this is really a missed opportunity in many respects because of the way the matter was put on behalf of the builder. I don't want to be heard to be criticising the team that represented the builder. It's far from it, be it from me to do that. I wasn't in the matter, and there may well be very good reasons for the way the matter was approached, but I do think it is worth exploring that because it necessarily will inform, I think, the value that can be placed by us on the final decision that comes when it does come, because it will necessarily have been informed by the way the matter was put, by the way the matter was argued, and for the reasons that I'll explain, some, I think, important concepts were perhaps not put as strongly as they could have been, and the result, I think, will reflect that. So the appellants in the High Court ran arguments which really echoed the points that I think have been articulated for you by Derek. There were three essential limbs to the appellant's argument. First, they said that the rights which have already been unconditionally acquired are not divested or discharged upon termination of a contract. That's the point that comes out of the McDonald and Dennis Lascelles case, which Derek mentioned. His Honour Justice Dixon indicated in a different context that where a contract is terminated, rights that have accrued as at the date of termination aren't somehow abrogated, but continue to apply and continue to bind the parties. That point was a central plank in the owner's argument, and as we'll see, that received, I think, some sympathy from the bench. The second limb of their argument was that if there is a valid and enforceable agreement governing the claimant's right to payment, there is neither occasion nor legal justification for the law to superimpose or impute an obligation or promise to pay a reasonable remuneration. That is, I guess, a way of putting the argument which Derek's indicated to you, that is that the contract should prevail where parties have agreed a particular regime by which one will be rewarded for the work it does for the other. The law should respect that deal and place it over some other vague, perhaps ancient entitlement to be paid some different amount. The third limb of the argument was that in the circumstances there's no room for a restitutionary remedy because the builder's claim is governed by a contract under which the work was carried out up to the time of the repudiation. That's really another way of putting, I think, the second point. That is that if we are treating quantum meruit as a restitutionary remedy, then there should be a proper basis on which to impose that remedy, and the owners unsurprisingly said that there wasn't such a basis. Developing those arguments a little bit more, the owners put 5 points. The first is that a quantum meruit remedy undermines the risk allocation that the parties have agreed. That is an interesting submission in the sense that I think it is part of the story, but what it perhaps doesn't elucidate is the fact that when parties agree a regime for payment under a building contract, then their risk allocation may well be quite complex, and it may well have, for example, or may well reflect a model on the part of the builder whereby cash flow is anticipated at different levels throughout the project to reflect or to properly accommodate the costs at the different stages of the project, for example, so that often costs for projects are quite high up front in the early stages, for example, and parties might agree a payment regime which reflects that. And it's not clear that when this submission was made, it was made with any regard to those sorts of nuances. It was really just a general, as a matter of principle, the parties have agreed a risk allocation, and QM subverts that. The second point they made was that quantum meruit exposes a principle to indeterminate liability. This is the idea that somehow parties should be held to their contract because otherwise an owner won't know what they're up for. Now, a couple of problems with that. First is the owners were the ones that repudiated, and so the argument in response to that is, and the builder put this argument, well, we had a contract, but you chose to tear it up, so to speak, and so that is what exposes you to indeterminate liability, not the remedy. The second point is the question of what a party will be paid, what a builder will be paid under a building contract is not fixed by the original lump sum price. Often it will often be varied to reflect some change in the work. There will often be adjustment mechanisms in the contract to change the price. And so on one view you can say, starting out with a project, that the price is nevertheless is still indeterminate because it may well be changed. The third point we've really made, restitution shouldn't be available where there's a contract. Fourth point, earlier authorities rest on the rescission fallacy. Now, I just want to spend a moment dealing with that. The point that wasn't made as strongly as it might have been on behalf of the builder was that a building contract, typically, and subject obviously to its words, will ordinarily be what's called an entire contract. That seems to be reasonably well established, and there are some quite old decisions, including the case of Gilbert Ash, which many of you will be familiar with, which stand for that proposition. What does that mean? Well, in simple terms, one needs to remember when one looks at a building contract that it is no different from any other contract for the supply of something. So, for example, the contract to purchase a motor car involves one person paying the other person for the motor car. In that case, the motor car is sitting in the showroom or might be coming on a ship very soon. You pay the money and you get the car. When you build a building, a house or something more complicated, you pay money and you get the building. The practice that's developed over many years is to provide the builder with the cash flow that's needed to build the building. The owner will pay the builder instalments by way of progress payments. And those will be paid perhaps monthly, and in New South Wales obviously we've got legislation which deals with those monthly payments. Those payments are on account of the overall price. They are typically in the contract described in that way, so there'll be words in the contract that say payments are on account. What the contractor has agreed to do is nevertheless to supply the completed project. That's practical completion, and usually contracts will have a provision or a mechanism that deals with the accounting at the end of the project on a final certificate, for example, to work out whether what the builder has been paid by way of progress payments properly reflects the total price, and there might be some adjustment if it doesn't. Now, what has emerged and what is apparent in the thinking of the bench in this case is an understanding that, in fact, progress payments are akin to payments for a series of severable obligations, so that the work that's done in month one is a severable obligation on the part of the builder, and when the end of month one is achieved or reached and payment is made, the transaction, if you like, is complete up to that point. But in my view, that's actually not a proper reflection of the way the law has developed in this area. Again, it depends on the contract, and the difficulty in this case was that there were no words to the effect that payments are on account in the contract. So it was a bit of a difficult vehicle for the builder to make the point. But the reason this comes up in respect of the rescission fallacy is that you can see when you look at contracts in that classical way that if the contract is terminated before you've got to that final reckoning, then it is not surprising that the builder can say, I've been paid a series of progress payments, but they're on account. What I was expecting to do was to get to the end and hand you over a completed project, and I have modelled my payments on that basis, and I'm not going to incur very many outlays in the final 2 months, but I still get paid my progress payments. That's when I'm going to make my money back. You've terminated before I get to that point, and you have effectively stymied my commercial model. And that's the basis on which I can say that you have torn up the contract, and I should be paid for the work I've done on a fair and reasonable basis, not on the price that we agreed, because the price that we agreed was built on this model which has been stymied. That's the doctrinal analysis which I think ought to have been put more clearly, and for reasons we'll come to, wasn't put terribly clearly. So the argument that it rests on a rescission fallacy is has some superficial attraction, but as I say, is perhaps not a full picture of the way the law has developed in this area. Finally, there was a sort of catch-all defensive point to say, if we're wrong on the other points, there's no alternative basis for granting a quantum Meruit. The arguments put by the respondent, as I say, were not quite as strong as perhaps they could have been, in the sense that this entire contract point wasn't made as powerfully as it perhaps could have been. Now, as I say, I don't want to be heard to be offering any views about why that occurred. There was a change in representation, and the way in which it played out was that the written submissions for the builder did not make the entire contract point in any depth, and so the appellants didn't come to court ready to meet that point. The written outline of oral submissions, which was served on the day of the hearing in May by the builder's new senior counsel did make the point somewhat obliquely, and again when the appellant opened and put its oral submissions in chief, it didn't grapple at all with the point. And if I could just briefly take you to some of the exchanges with the bench. I expect that counsel for the builder, well, perhaps the best way to describe it is it perhaps wasn't the best day at the office, but when Mr. Margetts of senior counsel for the owner made some points about whether the obligations under the contract were severable, His Honour Justice Edelman said, I may have missed this, but I did not understand the respondent, the builder, to contend that the payment under the contract was only in respect of an entire obligation of complete performance. And Mr. Margetts said, if Your Honour pleases, I know some recent cases were provided and I've just assumed that maybe the argument might be, and he was cut off by Her Honour the Chief Justice, who said, I do not think it has been put. And he said, quite sensibly, I will move forward then, Your Honour. And then when senior counsel for the builder got to his feet, he made, pretty early on, because I think he appreciated this was an important one, he said a proper characterisation of the contract is that the reason why work in relation to a severable part is being done is for payment, or to earn payment for that severable part. Then there could be no scope for a failure of basis, which is another way of putting the entire agreement point. And then His Honour Justice Edelman said, maybe that is the difficulty. We are talking about entire contracts rather than entire obligations, because the contract is a series of separate obligations, is it not? And then His Honour Justice Nettle said to senior counsel for the builder, you do not contend that this was an entire contract, do you? And he said, we do. He said an entire contract, an entire obligation to construct the entire building. Justice Edelman said, but there would be no payment unless the whole of the work was completed. Counsel, under the contract, there would be no right to retain progress payments if the whole of the work was not completed. And then Justice Nettle, a little bit later, said, surely the builder would have all his accrued rights up to the point of rescission. And it went on in that sort of flavour. And so what emerges from those exchanges, I think, is a view, and I may well be proved wrong when we see the reasons, but it seems from the exchanges that the view of at least His Honour Justice Edelman and Justice Nettle, and perhaps Her Honour the Chief Justice, was that McDonald and Dennis Lascelles applies. The rescission fallacy is the basis on which this quantum merit remedy has been granted. That's not a sound basis, because when you apply that McDonald-Dennis Lascelles approach, you have to give the builder what they've earned as at the point of the termination according to the contract, according to the price in the contract. And as I've said, I think there's some difficulties with that. But that seems to be the starting point on the part of the bench. Now, it wasn't explored in detail because what happened after that exchange that I've just read out is that their honours pointed out that this wasn't argued below. So the entire agreement point was not argued in VCAT. Perhaps that's not particularly surprising, but it wasn't argued in the Supreme Court either, and it wasn't raised in the written submissions. And His Honour Justice Edelman said, but this would require a notice of contention, would it not? Because your submission is that one needs to construe the contract as though all of the progress payments are in effect just payments on account. And counsel said that is part of my argument. Yes. Justice Nettle said Mr Margetts has understandably not said a word about the idea, and Her Honour the Chief Justice said perhaps you should consider the question of a notice of contention, and we might come back to that after lunch. So there was then no doubt some consternation over the lunch break, and after lunch counsel for the builder sought to return to the question, return to the topic of the entire agreement point. Her Honour said, well, you'll need leave to raise the question. The question of whether leave should be granted depends on whether it's got any prospects. We don't think it's got any prospects, so we don't grant you leave. So the entire agreement point was in effect nipped in the bud, wasn't put as thoroughly as perhaps it might have been. The point I've made about the way in which parties price particularly more sophisticated contracts was not explored. There is a question therefore as to whether the judgment that ultimately flows will grapple with those points. I think His Honour Justice Edelman, in his comments from the bench and also in his extrajudicial writings, has indicated, I think, pretty clearly that he's against the idea of the remedy of quantum meruit in a repudiation context. But again, we may be surprised. What His Honour indicated in a later exchange, which I won't go to, was a sort of hybrid approach where he seemed to have in mind that, and I think it's picked up in the Keating text, where the builder would be paid on the contractual rate up to the point at which the contract, if you like, stopped speaking. So, for example, if you'd done 6 months of work and you'd been paid 6 monthly progress payments, you'd get to keep those 6 monthly progress payments, even if they're on account, by the sound of it. And then if you'd done another 2 weeks of work, but you hadn't got to the point where you could put in a claim for the next month's progress payment, you might get quantum meruit for those 2 weeks, because the contract mechanism hasn't been properly engaged, and so it's odd to talk of the contract as controlling that entitlement. That's an entitlement that is left somehow to the law, but your accrued entitlements for all those previous monthly payments would remain, and that's what you get to keep. Now, again, in this case, maybe that's right. The contract didn't say payments are on account. Maybe that's the way to deal with a contract which doesn't say that, but it doesn't seem to be easily applicable to the sorts of standard form contracts that we see on larger projects, which usually do say that, and which usually treat these progress payments as not really an accrued entitlement, but rather a method of providing cash flow. And if you get to the end of your 6 months, how are you going to work out whether you've actually done the work that entitles you to 6 months pay or not? You haven't reached the final certificate. Now, what does it all mean practically? Well, we have to wait for the reasons, I suppose, but if these issues aren't made more clear, or if, for example, His Honour Justice Edelman's approach is adopted by a majority, it may well be that standard form contracts will need to change to pick this up. And it's possible, I think, to conceive of drafting that would help by, for example, setting out some mechanism which the parties choose and they say is applicable in a circumstance where the contract comes to an end before the final certificate, for example, so that payments might be stated to be on account in the usual way, but there might be some special provision that says that if the contract is terminated early, then this is how the entitlement of the builder will be worked out. I think the Master Builders Association contract might have wording to that effect, in the sense that it puts in words that effectively codify the QM entitlement. And so something like that might be needed if particularly contractors want to make sure that they can be sure of what they'll get if the contract is terminated early, even if it's terminated in a way which previously was treated as a repudiation and which resulted in the contract being thrown out. The theme of tonight's talk is the contract really irrelevant? And I think that's the question that was on the minds of the judges in Canberra. But for reasons that I hope Derek and I have explained, at least to some extent, the contract is certainly not irrelevant. The contract is very important, and even where quantum meruit is relied upon, it needs to be seen against the background of the contract that the parties have agreed. Are there any questions that anyone wanted to
I was
raise?
going to suggest that maybe if Derek and Lucas, you might stand there together so that our streamers can see what it's been.
Absolutely.
And if anyone, does anyone have any questions immediately? Excellent.
It's probably more of, I don't know, just thinking out loud. When you mentioned codifying quantum meruit in contract, that sort of piqued my interest, and I thought, well, what would be the point of quantum meruit then?
Quite. So what I mean by that is that, and I haven't got it in front of me, but I think the Master Builders Association contract might say something like, if the contract is terminated and the and there's a difference between what the work that's left to do would cost under the contract and what it would cost otherwise, then that will be taken into account in working out what is paid to the builder. Now, how would you do it in a way that helps the builder? Well, you might have some means by which the value of the work that's been done is identified, expert determination or something, so that the builder's not, if you like, left out of pocket by virtue of having taken work to a certain point but only been paid on a different basis. That's what I have in mind. But yes, it's I'm using quantum meruit slightly, it's in inverted commas, I suppose, because that's not what quantum meruit traditionally meant. But as I say, that's where the court maybe is going. It's seeking, I think, to find a way, or at least some of the judges are, to give contract preeminence over QM.
I mean, presumably another way of dealing with this is to make the progress payments be in step with the actual value of the work, so that the contractor has the quantum people in the audience may have a view on that.
Yeah, and some contracts do that. I mean, sometimes the QS will come in each month and work out what's been done, and payments will be worked out that way. Yeah, and
rather than waiting till the end to bring in the profit component.
Yeah.
Can I just ask, one of the things you mentioned is obviously the question of whether or not payments are on account or on for work performed to date and have contractual force. And to go to our old friend, the Lurking Security of Payment Act, all payments made under that act, progress payments for work, are specifically said to be on account, interim, and subject to the final rights and entitlements of the parties. So is there likely to be at some point in the future some question as to where one has enforced rights by way of adjudication and got payment? Does that need to account against a contractual position where in fact that's not interim but final for that stage of work? And what does that mean if that work is ultimately defended? So can you answer that question in 25 words or less?
A whole other can of worms, I think.
No, that's a very good point, Frank. I mean, that it's always difficult to reason backwards by pointing to an act and saying that act reflects the law, and you can see by that act the way the law in this area is developed. That's exactly what's happened. That act gives statutory effect to this tradition of progress payments, and the courts have said on a number of occasions that cash flow is the lifeblood of the industry and all that. But Section 32 expressly says this is not the last word. You're just being paid so you can pay your subbies and get to the next month. And that's the bit that seems to be missing from this idea of the rescission fallacy. Yes, if you've been paid, if you terminate and you've been paid under the Act, then presumably that's as good as being paid under the contract, and if the amount's right, I suppose you get to keep it.
Well, indeed, I was just wondering if say, Justice Evans does find that the whole entire contract concept is in fact no longer applicable, and these instalments are in fact mini transactions within the whole of the bargain, but yet in the future those mini transactions are actually being undertaken under the auspices of the legislation that inhabits all that work.
Indeed.
Indeed. I mean, Justice Edelman's extrajudicial writings are to the effect that there may be such a thing as a truly entire contract, and that in that context a quantum merit may continue to be applicable, and indeed that the unjust enrichment textbook edited by His Honour and another author makes that point, and indeed I think was footnoted in the submissions to the court.
Yes.
But the question that Frank raises about that interplay between SOPA and the contract and whatever decision is ultimately made in respect of this appeal is probably a matter for another CPD seminar, I think. Presented by Frank Higgs.
I just put my QS hat on for just a moment.
Yeah.
I mean, we talk about quantum merit as if it's like a magic wand to value the works. I mean, the principles we use often to formulate contracts in the first place are often very much the same principles we use on a quantum merit basis.
Yes.
Very much our method of measurement, the way we develop rates, the way we estimate the quantity of work, all very much the same. So quantum merit might be very much the same as it would have been when it was stated in the original contract.
Except to the extent that traditionally interpreted, a quantum merit turns on the value of the benefit conferred. And Frank and I had this discussion earlier. Frank says, well, what if, as a folly, a person decides that they want to have a purple cubby house was his suggestion, something that has that beyond the peculiarities of that principle, in fact, has no value. How does one value that? No, if ultimately the benefit that has been conferred is one that is either difficult to quantify or close to zero, well, is that the quantum of the quantum merit? And I mentioned earlier about how before the tribunal was faced with detailed evidence from a quantity surveyor, that it was quite traditional in the sense that there'd been the number of hours and the materials and so on to build up the value of the work that had been carried out. And on the other side of the record, there was the evidence from a building expert, but the tribunal preferred the quantity surveyor's evidence. That evidentiary matrix is one that formed part of consideration before the Supreme Court and the Court of Appeal. And the court said, well, yes, the contract price may be relevant, but it's not determinative. And faced with these different opinion evidence, it was appropriate for the tribunal. It was open to it to prefer the quantity surveyor's evidence and to treat that as being the value of the benefit conferred. So there's a slightly different lens through which one must look to analyse quantum merit, given that it's about the benefit conferred.
You get those clauses where it says if the principal repudiates and the builder then terminates, it will deem to be as if the principal's terminated for convenience and your entitlements will be measured accordingly. So are those clauses enforceable?
I think they probably are, and that's exactly the sort of clause that I had in mind. That's a good example. So that's a contractual mechanism to sort out what is owed in that repudiatory scenario, and I think that should be enforceable on its face. And if our impression of where the court is going is right, then it sounds as if that's exactly the sort of provision the court would uphold and say, well, that's the party's bargain. And they should be held to it. I mean, it may well be that what this case turns out to be is a case about what an entire contract is, because it may be that because of the words of the contract in this case, the ratio only applies in respect of contracts of that kind, and the court forms the view that it wasn't an entire contract, and that finding really just turns on the facts and turns on the characteristics of this contract. If that's where we end up, then, as I say, I think this is a missed opportunity in the sense that we won't then have much to go on in contracts that are of a different kind.
And that sort of clause, I might suggest, would be consistent with what Dixon said. That is
Yeah.
themselves
Yes.
expressly
Yeah.
referred to
That's right.
the terms of the bargain.
Subject to the
That's
to the
right.
contract.
That's
yeah.
right.
Yeah.
Yeah, I think those two things sit together, because if you say, on the one hand, your entitlement to progress payments is conditional, and this was one of the points that was made by counsel for the builder before he was told to sit down. If you treat those entitlements as conditional, then the Dixon view of the world works. You're entitled to be paid them. You can sue for them because you're entitled to be paid them. You just don't know whether you get to keep them. And the question of whether you get to keep them doesn't arise until after the point at which the contract has been repudiated. That's the problem. So the two things sit together.
Sorry, a question.
I think that a clause in the contract can limit the amount if you claim quantum merit or
Yeah, that's a good question. We haven't really talked about the ceiling. I didn't talk about the ceiling point, partly for reasons of time, and partly because the arguments on whether the contractual price is a ceiling in the High Court really didn't take things very much further than the points that I have explained. But possibly, but not if it is a classic quantum meruit. That is, not if the assessment is being made outside the contract.
Yeah.
It's a bit hard to bind. It's like one of those. It's like an entire agreement clause that says, any representations won't support a liability under the statute. Well, the courts will just work their way around those sort of provisions.
I mean, the entire premise of the availability of the quantum meruit is that the contract's no longer operating.
Yeah.
Well, thank you. Thank you very much for coming. I think you'll agree it is an interesting topic, even if Mann v. Paterson might be described a little bit as a family sedan at Christmas time, a messy vehicle. So thank you very much again for coming. Please join us for some refreshments afterwards, and could you join me in thanking Lucas and Derek?